we do anticipate that this will be probably roughly an hour, and then time for some Q&A. But we will try to be cognizant of your time and make sure that you get the information that you need. Now, one thing I did want to put out there, and we'll put it in the chat box too, is that this session we're going to be talking about post education opportunities for work authorization, the transition to permanent residency that might be available to you either through family or through employment. We don't have a lot of time or focus on some of the more immediate practical training options that you have. We do have a couple of slides on that. We will have a separate OPT and CPT workshop in 2 weeks that we're going to do. That's Trong, Chris, and I. We're going to answer questions that you might have about doing internships or employment using CPT or OPT, and that will be fully dedicated to just those topics. So if you haven't already signed up for it, please do. We'll make sure to share that with you, and I can follow up with an email invitation so that you guys can register for that. But with that, I would like to turn it over to Carol Armstrong and let her begin.
Good morning, and thank you, Charter. I appreciate the opportunity to speak to all of you today about planning for beyond graduation and some options that you may have for continuing your legal status and work authorization in the United States. We're going to kind of talk through today, as Charter mentioned, not a lot of detail about OPT and other options for practical training. His office is going to cover that in a separate session that hopefully you'll all register for so that you can get some detailed guidance on those options. But what I want to speak to today is I want you to start planning and thinking about these issues of continuing your employment authorization and lawful status in the United States beyond your practical training periods. You know, and Amy Brown with the Career Services Office is with us this morning to also provide her insight and guidance on thinking about making career choices and employer options and choices to help make sure that you can attain your immigration related goals as well. So we'll have Amy's insight on some of those options as we go through the program as well. For purposes of planning for students for the longer haul beyond school, one of the things that you've really got to take into consideration is you can't wait to make these sorts of decisions and considering and weighing of options until the very last minute. These are things that you need to plan for well in advance, and I'm hopeful that today that I can give you some information and guidance that will help you for some of that longer term planning. We go to the next slide, please. So employment-based temporary work authorization and lawful status. Many of you will seek OPT, optional practical training, as an option for employment authorization and maintaining lawful status in the United States after you graduate. Again, we won't get into a lot of detail about those options today, but keep in mind that depending on your field of study, you may have a year to up to 3 years of this work authorization that allows you to seek employment without having to have specific employer sponsorship, if you will. And again, you know, they'll get into some more detail about you, detail with you about, you know, the STEM OPT options and, you know, the employer obligations that may go along with that. But just suffice it to say that this allows you the opportunity with this particular practical training work authorization to get out into your field and to, you know, show your stuff, if you will, to your employer, to show them that you have the aptitude and work ethic to be retained as a longer term employee. So that is extremely important, having that option. And again, as they will discuss with you in their separate session, that is something that you also need not wait until the last minute to pursue. And indeed, you may put yourself in a situation where you won't be eligible for OPT if you wait too long. So it's important, again, to make sure that you're following the International Services Office guidance on when you need to be collecting documents, when you need to be filing your applications for OPT, and other related issues on maintaining your status after you graduate, including issues with travel and the like. Next slide, please. One of the things that I want to make sure that you know about are the options for temporary and permanent status, permanent residency. What you need to understand, there are basically three paths to either temporary status in the United States or permanent status in the United States. And those are usually based on employment. And if you don't have employment sponsorship, then you may fall into a category where you can have a family member apply for you for some sort of temporary or permanent status. And then we've got some protection categories as well in both the temporary and permanent tracks, which are cases involving, you know, folks who are filing for asylum, folks who are filing based on being a victim of domestic violence, for example, based on being a victim of other types of crimes, being a trafficking victim. And so those are categories where someone is seeking protection from harm, typically. We're not going to really focus on a lot of that today, but I want you to be aware of some of those categories. What we're going to primarily focus on today is going to be employment-based options for temporary status and work authorization, and some of the longer-term permanent resident status that you would be based on employment offers. So as Charter and Chris and his office will discuss with you later on in their separate session, you know, OPT is going to be for a finite period. It's not going to last forever. So you've got to know just some basics, and particularly planning for, you know, having work authorization and lawful status in the United States after your OPT expires. So you may have heard of the H-1B. The H-1B is a temporary employment-based status, but the H-1B option, it very well may be something that you are able to do if you have an employer who sponsors you for that, but it's full of traps, if you will, so you need to be aware of all of those. Can we go to the next slide, please? One of the primary things that you need to watch out for is to be aware that there are caps, the annual caps on the number of H-1B that are available. So the H-1B is an employer-sponsored status. So in other words, you have to have your employer will have to petition for you. And the H-1B is for a specialty occupation. In other words, a job that requires a minimum of a bachelor's degree in a particular field of study. So if you've got a position, you know, where you're a manager of a food store, that's probably not going to qualify for an H-1B, because you could, although, you know, there are people who can do that job without a degree, there are various fields of study that would probably qualify you for that position. So that might not be. An example of a position that might qualify for an H-1B, and likely does, if you are, for example, if you're seeking a job as an instructor or professor at an educational institution, if you are, let's say, working as an accountant in a CPA firm, if you are working in an IT type of position that requires at least a bachelor's degree in a particular field of study. Those are the kinds of jobs that might qualify for an H-1B. So every job is not going to qualify for H-1B. So that'll be one of the things that you'll have to take into consideration, and be sure that when you are searching for jobs, that you're searching for ones that may have some options on a longer term basis for you. And that's where the Career Services Office can also be of assistance there. So one of the things that the biggest obstacle for the H-1B under the current law is this annual cap on the number of H-1Bs available. So currently there are a total of 85,000 H-1Bs available each fiscal year. Excuse me, the fiscal year starts on October the 1st, because that's the fiscal year for the US government. And typically employers have to register for the H-1B selection process, if you will, usually in March. That process changed last year. It used to be that employers would just send in all of their H-1B petitions the first week of April for a start date of October 1. And the Immigration Service would go through and randomly by computer select the 85,000 that are available and would send all of the other petitions back. And that process, they figured out that that wasn't the smartest way to do it. So they now are requiring the employers to submit just a registration, if you will, to register for the available H-1Bs. And then the process is run and only the 85,000 are selected, and the other people who registered, the other employers who registered, are not able to actually file an H-1B petition. It's only those employers that are selected in that registration process. The reason that process is in place is because there's only this 85,000 H-1Bs available, new H-1Bs, but typically we see about 3 times that many petitions filed with the Immigration Service each year. So that's something that you have to be aware of. And typically what I advise people to do when an employer comes to me and says, hey, I have this employee that's on OPT and he's going to have 3 years of OPT. So when do we need to start, looking at trying to get an H-1B for him? If that employer is subject to the cap, I generally tell that employer the sooner the better, because although you would have 3 years of OPT if you're STEM qualified, you may not get selected if you wait until that last year. So I generally tell employers, at least by the 2nd year of OPT, they should be at least submitting a registration so that they get a couple of opportunities to actually be selected. There's no guarantee that just because an employer registers for an H-1B that he will get that for you. So it's very important to start planning for this early. So an H-1B is employer specific. So if ABC company is the one who petitions for you and you are approved for an H-1B, you're only allowed to work for ABC. The H-1B is also job specific. So the actual position that you are offered for the H-1B is the only job in which you can work under that H-1B approval. And of course, it's also location specific. So if you are, you go to work for ABC company at their office in Tuscaloosa, Alabama, and then they want to transfer you to Chicago, Illinois, then the employer would have to amend your H-1B petition and get you approved for the Chicago location. So that's very important that you understand that an H-1B is not portable, if you will, to just transfer from one employer or one job to another without actually making some additional filings with the Immigration Service. So let's talk about, do we have any general questions coming up, Chris, at this point that we need to address on the H-1Bs?
No, nothing yet. So you can move on.
Okay. I want to make sure that everyone understands this cap exempt versus cap subject employer. when I tell you that there are 85,000 H-1Bs, new H-1Bs available each year, what that means is there are 65,000 that are available for all potential applicants. And then there are an additional 20,000 H-1Bs available for folks who have earned a U.S. master's degree. So if you have a U.S. master's degree, you've got a bit of an advantage in the selection process because you get a couple of opportunities to be selected in the 20,000 number pool as well as the 65,000 number pool. So what is a CAP subject employer? What is a CAP exempt employer? Whether or not you have to worry about all these annual caps depends on who your employer is. So CAP exempt employers, Charter, do you or Chris know of a type of employer that might be a CAP exempt employer?
Why, I do. So generally speaking, any higher education institution, and that's not just the nonprofit or public universities, but private universities and even for-profit universities, as long as they're a recognized higher education institution, they're generally exempt from those caps. And the reason being for the obvious, which is if we had our professors start on October 1, it would be too late for our fall semesters because we all start in August and September. We need our faculty to be able to begin when we need them to begin.
Excellent. So yes, we do have CAP exempt employers that include educational institutions. There are some research organizations, there are some governmental type entities that also would be exempt from this annual cap. Unless an employer is specifically exempt from the cap, however, then they are going to be treated as cap subject, and thus these rules about the October 1 start date and the registration process and random selection or lottery selection, if you will, all of those rules are going to apply. So that's why I say it's very important when you are making, when you are searching for job opportunities, keep in mind that, you know, academia positions may be an option for ensuring hopefully that you will have opportunities for extending your employment beyond your OPT. So that's something to think about. Obviously, not everybody's going to go to work for an academic institution, so you'll want to look at private employers in particular. With your CAP exempt private employers, going to have some companies that are well versed in immigration processing and know the ins and outs. Some companies, like for example a Microsoft, who would have in-house immigration attorneys who would handle all of their processing for H-1Bs and other types of immigration processing. And then you're going to have other types of employers, and some of those may be small firms, some of those may be medium-sized companies that aren't knowledgeable about the immigration process, or they just don't want to get involved with the bureaucratic red tape, if you will, that is standard for immigration processing. So Amy, maybe you could speak just a second about maybe give us a little bit of information in how your office can help with educating employers about some of those issues and maybe helping to identify an employer that may be more immigration processing friendly.
Absolutely. I think one of the first things that we do is just get it out there right there. If an employer wants to post an internship or a full-time position with us, we ask right away, you know, are you willing to sponsor, or does this, you know, job require a U.S. work visa? And that I think is really important, in that you'll know that right away, and we won't have you applying for jobs that, you know, that would be a waste of your time, or, you know, that where you'd have to navigate a really sticky situation, like Carol said, that would be less friendly to a visa. So Handshake, if you've ever heard of it, students, is the way that we post our jobs and how we sort of liaise with employers and get the jobs to you. If you go into Handshake and you click on the filters on the job search, there are two different options you can select, and I just pulled them. One is will sponsor or doesn't require a U.S. work visa. I pulled that, and right now there are 2,525 jobs under that criteria. And we also have a button that you can select that says accepts OPT and CPT. So there are just as many there, 2335 for that. All majors, all types. So the first thing we kind of do is just get that information ahead of time, and we can help you with that. You can check that out at your leisure. Another thing that we can do is just sit down with the employers when they come in, or we have a career fair. We often try to educate them about what that means. I have literature that we can give out to employers. We can also practice sort of with you about how you would bring that up in a discussion or an interview. And I think that's a great forum for just us practicing the conversation together. So definitely seek us out. We are specialized by major, and so generally the person you would go to would know more about your particular situation because of that. But we really do try to create a visa-friendly situation with our employers.
Thanks, Amy. That's very helpful. And I will second what she mentioned about practicing on how to have that conversation with a potential employer or, you know, a current employer, because you really want to advocate for yourself and make sure that you have longer term options. But it's you know, you have to balance that against being a new employee or a potential employee and not wanting to close doors that necessarily would have remained open to you had you not had that conversation. So it's really important to work on those issues and think about all of that ahead of time. Again, we're going back to the whole theme of all of this, and the theme that we'll carry forward and in the presentation on practical training is, you know, you've got to plan in advance. You've got to think about these issues because these are not things that are quickly dealt with or quickly, you know, the process for any sort of immigration option, as you probably are already aware, through obtaining student visas and the like, is that it does take your time. It does take planning. And you can often have, you know, several different people involved in making decisions. Okay, one other thing we talked about, that the H-1B is a temporary option. So there is a limit on the amount of time that you may spend in the United States in H-1B status. So your limit is 6 years. What that means is if you're approved for an H-1B, typically you're going to be granted H-1B status for a 3-year period. And then you can renew or extend that for another 3-year period. And then the only way that you can apply for additional time in H-1B are basically two options. And one option is that you depart the United States, you stay out for a year, and then you can come back and apply for an additional 6-year period. The problem with that, of course, is that in most employment positions, the employer is not going to be so happy about having to have you depart the United States for a year before you're allowed to come back. So that may not be an option unless there's an opportunity for remote work or something like that. The main thing that you need to be aware of is that there is the opportunity to extend beyond that 6-year limit if your employer begins residency processing for you in a timely manner. So what that means is by the end of your 5th year in H-1B status, if your employer has started the labor certification process, which is part of permanent residency processing for employment-based options, if your employer starts that, then you'll be able to extend your H-1B for additional periods of time. There are also some countries where there is a backlog for persons born in certain countries for longer term permanent residency processing. So if you happen to be in one of those categories, you can also extend your H-1B beyond the 6 years until you're allowed or catch up in the backlog to where you are allowed to then complete your green card or permanent residency processing. So do we have any other questions about H-1Bs? I'm going to move on to some other types of temporary employment and status options.
Actually, there were several questions that came up, and Chris has done a really good job of answering a lot of those, but it might be worth bringing some of these things up. Chris, did you want to go through some of the questions that had come up?
Yeah, there's a really good question that Ruben asked, and I think a lot of people would benefit from. And Carol, you're more than happy to answer it, or I can. But it's, how do you apply for an H-1B? How do you get started?
Well, I'll let you get into the weeds with it, but the very first step is the conversation that Amy talked about, with having that conversation with your employer to make sure that the employer is willing to sponsor you for an H-1B. And once you have that conversation and your employer is willing to do so, then unless you got someone with your employer who handles the H-1B and immigration processing, then you might also want to seek out advice from an immigration attorney, where you and your employer can discuss, the actual process, the costs, the timelines, and make sure that you actually will qualify, or your position will qualify for the H-1B. Obviously, the University of Alabama has someone who handles H-1B processing. So Chris, go ahead and kind of talk through what some of the process, more details about how the process works.
Sure. So as I was telling Ruben in the chat, that how it's actually done and who you work with is really going to depend on who your employer is. And so here, if you get a job here at UA, you'll be primarily working with me. And, you would need to actually have at least have the offer has officially been made to you if you haven't officially accepted. And then the nice thing about a higher education institution is 99% of our positions are qualified for an H-1B, but and usually most of my cases are pretty straightforward. And I'm probably kind of opening a can of worms here, but there are some positions that we have seen recently in the last 4 years or so that have been really, really scrutinized, like IT positions and things like that. And so I would, depending on your position, I would kind of talk with you about the possible risks, look at your case very specifically, and address any possible issues that we may see, and kind of build a course of action. But if you are employed somewhere else, I would be able to answer very, very kind of general questions like we're doing in this session, but your specific case and your specific employer, I would really have to say, you really need to be working with your employer exactly. And if they have provided you a lawyer, work with that lawyer, or as Carol mentioned, discuss about finding a lawyer to handle your case.
And one other thing to keep in mind, if you're working through Career Services Office, they are going to help identify those employers that are willing to sponsor for employment authorization. But if you have an employer who is willing to do so, one of the things that the immigration attorney will make sure that the employer understands is that the employer is required by law to pay the cost associated with the H-1B processing. And that includes all of the filing fees, which can be substantial for a private employer. It also includes attorney's fees. So that's something that you need to be aware of. Like I say, if you've got a situation where the employer has somebody in-house who's going to handle that, you may not have attorney's fees involved, but the employer would still be responsible for paying the filing fees for your H-1B. And those can be, all of those costs can be, can be expensive. So that may, cause some employers to pause on whether or not they want to spend the money. So that's just something to think about. And that's why it's important, again, to have those conversations early. Any other questions that we want to address?
Let's see. Oh, there's one discussion about the cap and what is the cap, how much is the cap, and do certain degrees get certain preference over other types of degrees in terms of the cap?
Well, as far as the cap goes, the only degrees that get preferential treatment, if you will, are U.S. master's or higher degrees. Okay, so if you obtain a master's degree here from a U.S. institution, then that's going to put you in priority for the additional 20,000 H-1Bs, and you'll also have a shot at the general pool of 65,000. So it gives you two bites at the apple, if you will. Unfortunately, not unfortunately, but there are discussions, or there were discussions with the last administration about narrowing the opportunities that would be eligible for H-1Bs and prioritizing higher paid positions for those. All of that has been put on pause. All of those changes have been put on pause by the new administration. So we're hopeful that maybe we'll get some guidance on whether or not those sorts of issues are going to continue to be advanced. We don't expect that they will, but it's hard to predict what may happen in Congress, unfortunately.
Carol, I was just going to add that extra allotment of the 20,000, it's for master's degree and higher. So any advanced degree, basically,
yes,
that is earned in the U.S., not so it's not a master's from outside of the U.S. You have to have earned it from a U.S. institution.
Right, exactly. Other questions?
We got a few. I know some of it's going to be touched on later. Some of it was about the 6-year limit and for H-1Bs. There was a question I think that might be best for Chris, actually, about what visa do you, if you get a postdoc position, which visa should you go for, J or an H-1B? And so that's always a big question here. So
yeah, that's a really good question, and it really it really kind of depends on your situation. A lot of it depends on, are you in the country? Are you outside of the country? When does your boss need you here? And 9 times out of 10, your boss needed you here 3 weeks ago. And so it just really depends. A lot of it also depends on, are you already on an H-1B and you're coming from another institution? So I hate giving those kind of wishy-washy answers of it depends, but it really does. Because if you're within the country and you're already on a visa status, it might be 9 times out of 10, it's just better to keep your visa status if you can and just transfer here. But if you're outside of the country, most likely a J1 is going to get you here a lot quicker than say an H-1B. There's a lot of things that, quite frankly, I can avoid, primarily the Department of Labor and their requirements that I can avoid by doing a J1 rather than an H-1B. So it depends, and that's why Carol has reiterated, start this process early, because if we know this process early, we can kind of look at our options and get you here as soon as we can.
I think with that, we're pretty caught up on this. There's a few that will be more applicable later.
Okay, all right. Can we go to the next slide, please? Now, the temporary employment-based options are literally a bowl of alphabet soup, if you will. All of your temporary categories are given a letter for your status. For example, if you're in F status, you're a student, that's a temporary status. I want to kind of go through, we went through the H the H-1B option in a lot of detail, because I think that that may be something that many of you will be seeking at some point in your professional careers once you're out of school. But I also want to make sure that you're aware that if for some reason you don't qualify for an H-1B, or perhaps other reasons that the H-1B won't work for your particular position or your particular employer, we can look at some other options. These are all of these categories of temporary work authorization and status are very specific, and either you fit that category or you don't. For example, TNs, that's your NAFTA visa, if you will. And that is only for professional positions and only if you're born in Mexico or Canada, period. So if you're born in El Salvador, not going to qualify for a TN. But that can be, sometimes the TN can cover positions that maybe don't qualify for an H-1B, for example. So that's something that you can look at. But like I say, either you qualify for it or you don't. The O's are for exceptional ability in a particular area of expertise or skill. Again, either you're going to meet that very high bar that's required to obtain an O, or you won't. The E's are for, these are called treaty investors or treaty trader type positions. That's only going to be available to you if you're working for an employer that is based in a country that is subject to one of these treaties, and you are also of the same nationality, or at least your sponsoring person is of the same nationality. So that, again, you either qualify for that or you don't, or your particular job offer qualifies for these or they don't. These are, again, options that we go through. If a lot of times your employer's immigration attorney may look at the H-1B first, but there may be times that we go straight to, hey, we can do a TN because this person is from Mexico or this person is from Canada. So it really is just an analysis to see if you fit one of these categories. Next slide, please. The L's, those are only available for what we call intracompany transferees. And one of the requirements to obtain the L is that you have to have, your employer has to have operations both in the United States as well as outside the United States. And you would have to have worked for that company that's based outside of the United States for at least 1 year within the last 3 years. So those may not be immediately applicable when you get out of school, but it may be something that may be an option later on if you go work out of the United States for a while and then need to be brought back in because you have some sort of specialized knowledge about the company's operations or products or services, or if you're an executive or manager level employee. So it usually is not something that we seek out immediately post-graduation, but it's an option that may or may not qualify. Your P's are going to be for your athletes. Your B's those are just visitor visas. Some of you may have actually had a visitor visa in the past, but those are not going to provide any sort of work authorization as far as the B's go. One thing that I want to make sure, and I always try to point this out with any group that I speak with, are your U visas. If you have been a victim, if you, or in some situations, one of your parents or your siblings or your spouse, if you're married, or your children, if you have children, if either of those people have been a victim of a qualifying criminal activity and the person reported it, and also cooperated in the investigation and prosecution of the crime, in those situations, you may qualify for a U visa. And those can provide some work authorization and lawful status, as well as provide you with an opportunity for permanent residency. And this is not just any simple crime. It's not, somebody broke a window in my car in the parking lot. That type of crime is not going to qualify. Victims of domestic violence, victims of sexual crimes, victims of assault and felony level assault. That's usually when you've got pretty significant physical injuries, or maybe there's a weapon involved in a robbery and assault. Those are the types of crimes that typically are going to qualify for your U visa. So it's, again, if you're in that unfortunate situation and are a victim of one of those crimes, it is certainly worth, seeking out advice from an immigration attorney to see if that's something that you may qualify for. All right, do we have any questions about any of the other temporary categories before we move on and start talking about employment-based permanent residency?
There's nothing on these temporary options. There's some more PR related stuff. Okay.
Well, let's move on into the next slide and let's start looking at some options for employment-based permanent residency. Now, remember we talked about there are 3 primary paths to permanent residency. That's either going to be based on family relationships. We'll talk about that briefly. Maybe you're in one of those protection categories. For example, if you're seeking asylum based on a fear of return and persecution in your home country. Some of the U visa, the victims, there are paths to permanent residency through that, as well as the asylum track. So you'll fall in one of those basic tracks. What we're going to spend most of our time on this morning is talking about employment-based permanent residency. So I want to make sure that you understand, again, we go back to this theme that's running through, is making sure that you are planning ahead. Because one of the things that the basic questions that I get on a daily basis, and I'm sure Charter and Chris and Trong probably get these questions, how long is it going to take? How long, what do I need to, what time frame do I need to plan for? And our response, I'm sure that you guys have made this response before as well, it depends on a number of factors. We can give you, based on our experience in dealing with particular types of immigration matters, we can tell you kind of what the trends are, what we're seeing, what our expectations are, but there are so many things that can impact overall processing times on and waiting for permanent residency processing. So that's something that we can certainly give you some guidance on and advise you on kind of generally what to expect, but there's no way that I can tell you it's going to take 23.75 days to get your H-1B visa or whatever it may be. I mean, that's just not something generally that we can give you, 100% accuracy guidance on, because there are so many factors that play into that. Anytime that you're dealing with employment-based permanent residency, you're going to have at least 1 or 2 government agencies involved. And within those government agencies, you're going to have, national service centers, and you're going to have field offices, and you're going to have local fingerprinting offices that are all going to be involved, and any impact to any one of those particular players can make the processing times much longer, make the wait much longer. You're also, as far as you've got USCIS, which is U.S. Citizenship and Immigration Services, that would be the office that would process both temporary types of processing, H-1Bs, for example, as well as permanent residency processing. You've also got in a large percentage of your employment-based processing, both temporary and permanent, where you have the U.S. Department of Labor involved. And as Chris mentioned earlier, sometimes dealing with the Department of Labor regulations is the most frustrating part of the process many times. Also, you will have the U.S. Department of State. There are visa numbers, and those are permanent visa numbers that have to be allocated each year by the type of category in which you're applying, as well as based on your country of birth. And so that allocation of those permanent visa numbers also has an impact on overall processing time. And we'll talk about that in a little bit more detail, but basically, I want you to understand when you're waiting to get into the permanent residency process, or once you begin your employment-based permanent residency processing, you need to understand that it's going to take some time, and it's going to take longer. It may take longer depending on your country of birth, depending on the category in which you are applying. All of that can be impactful. So it's important that you are maintaining your underlying temporary non-immigrant status and work authorization, because while you are waiting to get your permanent residency approved, most of you will be in the United States. Most of you are going to be working. So you're going to have to protect your underlying status as well as your work authorization. And you need to be sure that you're talking to your advisor or your immigration attorney about the impact that travel out of the United States can have if you are involved in permanent residency processing, because there are some types of underlying status that do not allow you to seek permanent residency. And if you do so and you travel out of the United States, you may be deemed to have abandoned your processing. So it's very important to talk with your advisors or your immigration attorney and make sure that you know the impact of traveling out of the United States. The time to have that conversation is not when you have already left the United States and have been refused entry. The time to have that conversation is before you travel. Before you leave the United States, because unfortunately, if you leave while you're in the course of permanent residency processing and you have not, confirmed with your advisors that you're going to be allowed back in with your current underlying status, then you may have some problems there. So just want to make sure that, again, this all goes back to making sure that you're planning early, that you're talking with the folks in the know, your advisors, to make sure that you are protecting your underlying status while you're in the course of the permanent residency processing. Charter, do you or Chris have anything to add on that?
Yeah, absolutely. I mean, everybody on this call or on this meeting today is primarily on an F1 visa, and if not, they might be on a J1 student visa. And these are exactly the types of visas in which travel after permanent residency filing has reached a certain stage would be problematic, because your immigration status as an international student is as a non-immigrant, and so you're having to prove non-immigrant intent when renewing a visa or when re-entering the United States. And that green card case, that permanent residency petition, once filed, it is a declaration that your intention is to seek permanent residence, that you have immigrant intent. And so it's in direct contradiction with your non-immigrant status that you're trying to claim to come back. So it's not that it can't be done. We've had folks do it. It's just, green card processing takes so long. You have to have plans, and that's a big reason why Chris does H-1Bs as soon as he can for new faculty. They may start on OPT, and they may even have multiple years of OPT eligible to them, but it sometimes makes a lot more sense to go ahead and move forward with that H-1B right away, rather than relying on that OPT work authorization, for the very reason that we don't want a faculty member, an employee of the university, stuck outside of the United States. And has it happened? Yes. I've worked in this field for a very long time. I have had faculty stuck abroad who couldn't get back in because they didn't have an H-1B to protect them to get back in, because they were stuck in a permanent residency process that contradicted their F or J status that they held. So it's a big deal. We ask about travel a lot. And please, I beg of you, as you go in with your employment, you don't have to let them know when you're going to the beach, but let them know when you're traveling internationally, because it could really disrupt your ability to get back to work on time.
And Charter, I'm going to steal your line, but right, most of us, we have, when we make travel plans, right? And right now, our intentions for most of us are not travel unless, internationally travel unless we have to. But it's always the unexpected travel. When does that come up? And so that's something that you should take into consideration, right? So most of us aren't planning to travel, but, for example, I have a father who's elderly and I have to go back often. That's just in the United States, right? But what if something like that situation, something like that you would have to deal with? So while you may not intentionally have the intention of traveling anytime soon, you may want to, if you can, switch over to an H-1B. I usually advise doing it because it gives you a lot more flexibility.
Thanks to both of you. I think that's very helpful because it is such a, can have such extreme negative consequences if you're stuck outside. And if you're in employment-based permanent residency, that may put your job in jeopardy if you're not able to return to the United States. So you want to make sure that you make plans accordingly for that. So let's look at the next. Slide. Chris mentioned the U.S. Department of Labor and the headaches that we deal with in dealing with the U.S. Department of Labor. There is an employment-based permanent residency process that involves dealing with a test of the labor market, as well as having the U.S. Department of Labor certify your permanent position for processing further with USCIS. So if your employer decides that, maybe you get the job, you start working on your OPT, and then let's say you apply for an H-1B and you're lucky enough to be selected in the lottery, and you are then working on your, second or third year of H-1B, and your employer decides, well, this is a candidate, or this is an employee that I want to make sure that I'm able to keep long-term. And so I'm going to sponsor him for permanent residency. And so if that is the case, in doing so, the employer is required by the U.S. Department of Labor for many types of permanent residency processing to actually run a test of the labor market, if you will. So what that means is that the employer has to actually recruit that position, and the Department of Labor gives us specific rules that we have to abide by in running advertisements and the like, and where those have to be run to test the labor market, to find it, to make sure that there is not a qualified U.S. worker available. The qualified U.S. worker would be a U.S. citizen or a U.S. permanent resident. So the U.S. Department of Labor requires this process because it wants to ensure that jobs are not being offered, permanent jobs are not being offered to foreign nationals if there's a qualified U.S. worker available to take that position. So that in and of itself, that step in the process can take quite some time. It can take several months or even, longer than a year just to get through that phase of the process. Now, there is a special process that's available for universities, and that's for teaching positions. Your professors, your instructors, if they are longer term instructor contracts, those are going to qualify for some special rules, and sometimes that type of special processing labor certification can be completed a little bit quicker than it takes for the traditional type of recruitment. So just to kind of give you some background, if you're applying for permanent residency, you have to look at the category for which you apply, which can be, if it's one of these labor certification type cases, it's general and it requires the position requires a master's degree or higher, you're going to be in an employment-based second preference, okay? If your position requires less than a master's degree, you're going to be in the employment-based third preference, so EB3. You'll hear us talking about that, and the reason that is important is when the permanent visa numbers are allocated by the U.S. Department of State, those are allocated by category and by country of birth. So there are some countries that are in a backlog in the EB2 and EB3 categories. And typically, historically, those countries have been China and India. So if your country of birth is China or India, it will be particularly important for you to know whether or not which one of the categories you're going to be eligible to apply. So labor certification typically is going to fall within an EB2 category or an EB3 category. And those are typically backlogged pretty substantially for several years or longer for people who are born in China or India. India has historically been impacted the worst as far as the backlog goes. The reason for that is there's just a lot of demand for foreign nationals born in China and India. So the amount of permanent visa numbers that are available for foreign nationals from those countries is the demand is greater. So the numbers run out more quickly. And then we have the backlog situation. So let's go on to the next slide. I want to talk to you a little bit about one of the processes that's in the EB2 category that does not require labor certification. The good news about the national interest waiver process is if you look at the labor certification based process, it requires the employer to agree to apply for you and to sponsor you and to pay certain of the costs involved in the permanent residency process. Alternatively, the national interest waiver is something that you can self-petition for. In other words, you do not have to have an employer agree to file this petition for you. It may be that your employer is unwilling to petition for you, or it could be that your position does not qualify for labor certification because it's not considered a permanent position. So, Charter, could you think of a type of position, maybe at an educational institution, that might be a good candidate for a national interest waiver and would not otherwise qualify for labor certification?
Absolutely. So postdoc positions, by its very nature, a postdoctoral researcher is not a permanent position. It has a very finite length of time and of employment, and thus we can't sponsor a permanent residency petition for a postdoc. So we have many postdocs that seek the national interest waiver route because they meet the other qualifications.
And just to generally talk to you about what the national interest waiver application or category requires, the three prongs that the Immigration Service will look at is whether or not your work has substantial merit as well as national importance, and you, the applicant, are well positioned to advance your work, and it would be beneficial to the U.S. To waive the requirement of labor certification. So it's a process where you can just completely bypass labor certification and go direct to filing your petition with U.S. Citizenship and Immigration Services. So what types of evidence or proof would you need to show that you qualify for this national interest? It is a subjective category, which means it's not a just check the box if you've got 1, 2, 3, 4 that you automatically qualify. No, it's a subjective review by an immigration officer of your particular body of work and its importance and beneficial to the United States. We look at the next slide. These are just some of the types of information, proof that you will need to submit to show that you qualify for a national interest waiver. You've got to look at the prospective, the potential prospective or future impact of the work that you're doing. How do you demonstrate that national importance? You've also got to show the substantial merit. Is it going to, or is the work that your body of work, have you received any sort of research funding, grants? Are you likely to? Can you demonstrate that you're likely to receive those? Or is the work that you're doing going to benefit the United States by creating jobs or employing U.S. workers? You've also got to show that you in particular are well positioned to advance that work, that endeavor, if you will, by showing your past accomplishments, by showing a plan for the future work, showing the progress that you've made in your work, and showing interest from the outside. Basically your publications, presentations, expert letters, if you've got interests by certain governmental agencies through research funding or otherwise, those are the things that help demonstrate that you're well positioned to advance your work. Is a job offer impractical? You know, would it be that that's where you really have to show that your work brings that national benefit, the national interest is urgent, and so you've got to show that we don't have time to go through labor certification process. We need to advance this work more quickly than that, and I, the applicant, am the one who has the ability to do so. Leadership in your field, of course, is a positive factor, and that goes back to some of those things on your publication records and your presentations and that sort of thing. So all of those types of pieces of evidence are important for putting together a successful national interest waiver petition. Keep in mind that this is something that you can self-petition, but I always encourage folks to make sure that you're getting some advice from an immigration attorney or having an immigration attorney actually prepare your case, just because there are very detailed regulations and policies and processes and that you'll need to be aware of in making the argument for the national interest waiver case. Chris, or either of you guys have any additional thoughts about the national interest waiver before we look at a couple other categories? Or do we have some questions?
There was one question that came up, but it's kind of related to that travel, same travel scenario. Is like if someone does the national interest waiver, is it advisable to travel while on F1 OPT?
Well, the mere filing of the national interest waiver petition, which is the I-140 petition, in and of itself is not considered demonstrating immigrant intent. However, it is a factor that someone issuing a visa, a consular officer who's looking at a visa application, or even a CBP officer may look at in determining whether or not you'll be admitted at the port of entry. So it is something to consider. That's one of those questions that typically, well, I won't say typically, but a lot of people file that national interest waiver petition and wait for it to be approved before they spend the time and money to actually file the second piece of the puzzle, which is the application to adjust status to permanent residency. And so a lot of times you may have a year or longer that you're waiting on a decision on your national interest waiver petition. And if you travel within that period of time, you could have issues.
Another one that's not related to the national interest waiver, but it was related to, and I don't think we touch on it in this, but the lottery, the green card lottery. What kind of impact could that potentially have for your non-immigrant status by applying for the green card lottery?
Yeah, it depends on if you're just submitting the registration, that in and of itself should not be enough to cause you to be denied entry or denied a visa. In my experience, now that is always subject to change.
Great. I think we're caught up, well, with the exception, I know we're about to go into the EB1, but one of the students asked for EB2 and EB3, are you recommending not applying for those that are from India or China because it'll take so long?
No, absolutely. I'm not suggesting that. It may be that, and we're going to talk about the EB1 categories here in just a second, but it may be that you start out with an EB2 or an EB3. And the reason that it's important to do that and to do that actually make those EB2 or EB3 filing as soon as you can is because it secures your place in line. In other words, if the lines are a lot longer for India and China, and there's not a literal line, but let's just, for painting the picture, let's suggest that there's a line and you're standing in line. The sooner you can get in the line, the sooner you get to the front of the line. Okay, so maybe you file an EB2 or an EB3 petition, you secure your place in line, and the line's really long in EB2. Okay, but let's say for an EB1, you know, a couple of years later, or maybe even 3 or 4 years later, maybe you know, your work demonstrates that you'll qualify for an EB1 filing and approval. The good news is you get to keep your place in line. So you just move out of the EB2 line wherever you are with your date, and you move over to that same place in the EB1 line. So you don't go to the back of the EB1 line because you're already in line. That goes back to that visa allocation by the U.S. Department of State each year and how it's allocated by country and by category. Typically, and of course it's always, there are always caveats, but typically the EB1 category is more advantageous for people from China and India because the line, if you will, is not as long. In other words, there's not as much of a backlog in the EB1 as there is for EB2 and EB3. So what that means is you go ahead and get in line by filing an EB2 or an EB3 as soon as you're eligible. And then perhaps you file an EB1 later on. You can do that. You can have multiple petitions if you, rather than wait 3 or 4 years down the road until you meet the requirements for an EB1, perhaps go ahead and, if your employer is willing to sponsor you, go ahead and file the EB2. And then get your place in line so that you will be further along in the waiting periods once you do get an EB1 approved. And we do that, I do that quite frequently for clients who, you know, at the beginning, as soon as they've graduated and they've secured a position and their employer's willing to sponsor them, at that point they qualify for an EB2, for example. And so we go ahead and file the EB2 and get the place in line. And then 3 or 4 years down the road, sometimes 2 or 3, maybe their accomplishments, they built up their CV and accomplishments to the point where they are able to go ahead and file an EB1 and get that approved. Well, it's advantageous because they've already secured their priority date or their place in line, and they're able to complete permanent residency processing much faster based on the EB1 filing. Any other thoughts on that, guys?
Only thing is just to reiterate, that's usually our options. We regularly do exactly that. We qualify for an EB2 case for new faculty hires. We have a lot of new Chinese and Indian faculty hires. We go with what we have at that time. If they're a newly minted PhD, they're just not going to qualify for anything else, usually. And so we go with what we have. And then we move forward with a secondary filing later if that gets us through the process faster.
All right, let's go on to the next slide and let's touch on a couple of options in the EB1 category, and that's employment-based first preference. Typically, to qualify in an EB1 category, you're going to have to demonstrate that the EB1s don't require labor certification. Like the EB2 national interest waiver doesn't require labor certification. The EB1 though is typically a more advantageous category for China and India in particular, but also other types or other countries as well. With an EB1 filing, if you qualify for that, there's one category that does not require an employer sponsorship. We're not going to get into a whole lot of detail about it. It's called the extraordinary ability. But that's typically going to be someone who has, or in the very top percentage of their field, and have been working in the field for some time, or have some very major prizes or awards, command a high salary in their field, have held significant positions in the field. those are going to be what I call the cream of the crop category. And there aren't a lot of those approved because they are very difficult to qualify for. Think of national interest waiver, for example. It's an EB2. So unless you're if you're from China or India, you may not want to file the national interest waiver if you have an employer option. Okay, if you've got an employer who's willing to sponsor you. An EB1, though, if you can show that you meet the requirements of extraordinary ability, and few people will, but there are some who do, then you may want to go ahead and just go straight to an EB1 filing because it does not require an employer to sponsor you. That's a self-petition. There's another EB1 category that the standard is not as high as the the extraordinary ability category, and that's your outstanding professor or researcher. Now, obviously, this is going to be primarily if you're working for either a university, an educational institution, and you've got a tenure or tenure track teaching position or a comparable research position. There are also private research companies. Some of those research positions can also qualify. One that I can tell you indeed that will not qualify for this particular category is going to be your postdocs. Again, that in and of itself may be why you would seek out a national interest waiver in an EB2 category, is if you've got a position that doesn't qualify as a permanent research position. So you've got to have at least 3 years of teaching and research experience in your academic area. And that is not just any teaching experience. It has to be teaching experience where you had full responsibility for the class taught. And a lot of times we can't use research experience that you gained prior to obtaining your PhD just because the research, we'd have to demonstrate that that particular research has been proven to be outstanding in the field. So next slide, please. So those are the primary requirements, or the preliminary requirements. You've got to have the 3 years of experience, and you've also have to have a position that qualifies as either a tenure or tenure track teaching position or a comparable research position. And the way that you demonstrate that you qualify for that outstanding professor or researcher category is you've got to show major prizes or awards, membership in an association which requires outstanding achievement of its members, material written by other people about your work, you serving as a judge of the work of others, such as, reviewing for journals, serving on selection committees, that sort of thing. Your own original scientific research, and author your own publication record. All of those are the types of documentation and evidence that you would provide to show that you qualify, and that you've got to demonstrate that you've been recognized internationally as outstanding in a specific academic area. You don't want to throw a bunch of weak evidence into your case, because this is not a situation where you want to just throw everything in there that you can possibly find. Weak evidence can actually be used against you and result in you being denied your petition for outstanding professor or researcher. So that's a category. Again, it's something that you need to be aware of, that it's out there. Either you have that type of position and you can meet those qualifications, or you don't. And if you don't, if your position is not going to qualify, you may have to look at an EB2 category, such as a national interest waiver or an employer-sponsored permanent residency. Do we have any questions about any of the EB1 or EB2 categories? And we'll talk briefly about some of the family relationships and just do some general issues.
Okay. We had just a couple of questions. I've tried to answer, and so has Chris, these, but one of them was, can experience earned outside of the U.S. Count towards qualifying for an EB1?
And the quick answer is yes, it can.
And then another is somebody, and I think this might be related to that 3 years of experience minimum qualification for outstanding research professor, but someone has been the instructor of record in lower and upper level classes since 2018. Would that meet those qualifications?
Yeah, if you're the instructor of record and you have full responsibility for the course taught, then yes, that would qualify.
Okay. That's very helpful. I do want to put it out there. If you're still a graduate assistant, though, your position is not a permanent position. So the University of Alabama cannot sponsor graduate students for permanent residency because your position is not a permanent position. We reserve that for faculty, full-time contractual instructors, and full-time staff. There's a whole checklist, but you might qualify under national interest waiver. So, I think that's it for right now. Let's move on to the next slide, if you're okay with that.
Yeah. All right, so I wanted to touch briefly on the family-based categories, just to make sure that you understand that there are options other than just employment-based options. We have focused on the employment-based options today just because we want to make sure that you're thinking about your future and your employment in the United States once you graduate. But if you have particular family relationships, you may be eligible to petition for permanent residency based on those family relationships. And one that is quite frequently happens is, you meet someone and that person is a U.S. citizen and you ultimately wind up getting married. Well, it actually can be a fast track to permanent residency. It doesn't take nearly as long as the employment-based processing. You don't have to get an employer to sponsor you. Basically, your U.S. citizen spouse becomes your sponsor and the person who petitions for you. So that is an option. Now, you do have to prove that it's a bona fide marital relationship. You can't just go get a marriage certificate and, with a friend who decides to help you out. Because that is marriage fraud, and that can result in prison time and fines and, of course, deportation. So I just want to caution you that it's something that you've got to demonstrate that it's a bona fide marital relationship. And in those cases, you and your spouse would be required to have an interview with an immigration officer who's going to ask questions and investigate to make sure that your marriage is indeed bona fide. There are also some other family-based categories, relationships. If you have, a parent who is a U.S. citizen or a step parent who is a U.S. citizen who can apply for you. If you have, a parent who is a permanent resident, then, that may be an option for you as well. Some of the categories, there are very specific categories and not every family relationship qualifies. So if you have a cousin who's a U.S. citizen, he's not going to be able to apply for you. If you have a sibling, brother or sister who is a U.S. citizen, that is a category that allows you to process based on that relationship. But there can be some backlogs with some of these family relationship categories. So you'll want to talk to your immigration advisor or attorney to make sure that you get some guidance and know what to expect as far as timelines. The reason that that's important is if there's a backlog in the category in which you're applying, you may not be allowed to remain in the United States while you're going through the process, and you won't have work authorization in the United States. Luckily, the category on marriage to a U.S. citizen, if you are married to a U.S. citizen and apply for permanent residency, you'll be allowed to stay in the United States, and you will be able to apply for work authorization through that marriage-based process. So it really is an advantageous category, but either you're bona fide married to a U.S. citizen or you're not. And if you're already married to a non-U.S. citizen, they're probably not going to be too happy if you say you want to marry a U.S. citizen. So I just want to make sure that you're aware of, those additional family-based options. But again, either you have the relationship or you don't.
I'm
Go
sorry.
ahead. No.
On the relation part, we did have somebody, and it was sent in a private chat, but about children sponsoring you, a U.S. born child sponsoring you. Is there any note that you would have about that?
Yeah, the only way that a U.S. citizen child can apply for you is when that child is 21 years old. So you hear a lot of people make derogatory comments about somebody having a child in the United States just so that they can get a green card, and that's not true. And it's really a fallacy to even suggest that, but some people do make that suggestion. The child has to be 21 years old, so you know that's not going to help you if your child is 3 or 4. One last slide. We have any other questions on that? No. One last thing that I want to make sure that we talk about, and this kind of wraps it back up to our theme of planning early. And our final slide, making sure that you're planning. Can we go to that last slide? There we go. You know, don't wait too long. Don't put this off. Don't wait to seek counsel about what your options are and what the timelines are. Make sure if you are married and your spouse's status is derivative of yours, for example, if you got an H4 spouse, or an F2 spouse, make sure that you're planning for their status and their travel and their work authorization. Many of the derivative categories do not have work authorization. So you got to make sure that you're looking at that. And then, of course, we've kind of beat this horse pretty good, but travel issues, you got to think about those. You got to make sure before you leave the United States that you don't have any issues that are going to cause you to be refused entry or refused a visa while you're out of the United States. So that it's just very important to address the issues head on and plan for it well in advance. Any other thoughts, guys, or any other questions?
No, this covers it very well. I would say from our perspective here at the university, you know, you're all, you know, in various visa statuses, but most of you are on F1 student visas. And it is really not uncommon for students to obtain permanent residency. We have probably 10 or so students every semester who obtain permanent residency either through family-based petitions, through their parents, or through marriage-based petitions, or some other qualification. What I would recommend is if you've got a pending petition, or if you've got a case that's out there, or if your case is approved, loop us in. Our office is actually the one that will then update the other offices on campus about your new permanent residency status. And just that impacts, of course, our continued sponsorship of your F1, and it will impact things like whether you get billed for international student fees. I can't tell you, I get some folks that get their green cards approved, and like 3 semesters later, they're saying, you keep charging me this international fee. Well, we didn't know that they had been approved for permanent residency, and so nothing has ever been updated. And as far as the system is concerned, they're still on a student visa. So, you know, things like that will be, just keep us in the loop. We're not going to get you in any kind of trouble. We just want to make sure that we keep everything updated, and we may not be able to advise on your permanent residency path. That's really outside of the scope of what our office can do unless you're our employee. But at the same time, you know, we can at least talk about potential impact that whatever you're doing might have on your current student visa status. So.
Well, I really appreciate everyone's attention today, and I hope that this has been helpful, and I hope that we've been able to address some of your questions and concerns. And you know, please feel free to see to see the folks at Capstone International or the Career Services Office for additional questions you may have. Be sure that you're registering for the OPT and practical training seminar or workshop that they're going to be holding as well. If you have additional questions, please feel free to reach out to me and I'll be happy to assist you if you have additional questions, or, you know, if you later have an employer who wants to sponsor you and you want to try to address some of the employer's questions. Thank you so much.
Thank you. And we'll stick around for just a second. They're having questions about whether or not the recording will be accessible. I do have the recording. It'll be saved to my desktop shortly. I will work on getting that uploaded somewhere so that I can share the link back out. And I'll get the slides converted over to a PDF to share back out to everybody. So be looking for an email from me, anybody who pre-registered. I see a few names in the participants list that weren't on the registration list. So I don't know if it was shared with somebody by being forwarded, or maybe that your username for Zoom is different from the one that you used to register. But I will send out to the registration list a link to the CPT OPT workshop, and if I've got the uploaded video, I'll have that shared with you as well. Well, thank you, everybody. Thank you so much, Carol and Amy. Career Center has been a great partner to us, and we try to do one of these every year, and I think that there's always questions that people have about that transition to life after the university. So we're extremely thankful for both of y'all's support, and Carol for taking so much time to do this with us.
Glad to be a part of it, guys.
All right. Well, we are happy to hang on here for a second or two, but if nobody has questions, we can wrap it up within the next couple of minutes.